you're under oath. And if you're found to have lied here today, that will be perjury. And, perjury is a criminal offense. So it was, it's pretty intense. And sitting in the witness chair is not fun. So starting off like that, being told, hey, if you say something wrong here today, you could be criminally prosecuted for it is not fun for our client.
Should we set the client up? I don't know if we did in this case, but isn't it a good practice to hey, the client, they're going to say all this stuff. Don't let that freak you out.
Yeah.
Welcome to episode 116 of the Weekly Docket, a podcast by the Silverman Law Firm where we talk legal news and practical law. Today is April 1st, 2026. I'm Phil Silverman, owner of the firm and your host, and I'm joined by Chris Hield, who's our firm's supervising attorney and co-host. Chris, big arguments taking place at the U.S. Supreme Court today, Birthright Citizenship. I'm sure you have not been following it, correct?
I have not. I saw something about it on social media this morning, though, and it sounded actually interesting. I kind of wish I had. Are they arguing as to whether people born on this soil are automatically entitled to citizenship?
Yeah, that's the whole thing. It's the 14th Amendment, all right? And it's, if you're born here, naturalized here, whatever naturalized means, in the United States, and you're then subject to the jurisdiction, you're citizens of the United States and the state wherever you reside. That's just kind of how it is, right? That was the 14th Amendment. So
yeah, the blurb I read said, because we know that those were Reconstruction era amendments, that it was really intended just to apply to the Black people who we were like, no, you guys are only 3/5 of a person. You're not real people. And so all those post-Civil War amendments were meant to say, no, you are in fact real people with real rights. You are citizens. And that's exactly what this amendment is for. It is not intended outside of that scope. So I thought that was interesting. I don't want to sound racist.
Here's what I want to ask you. If you're on the administration, the current administration side, okay, and we're saying we want to do away with birthright citizenship, and that's because it's just absolutely crazy that anybody can come here, get in the United States and have a baby and get an anchor baby here. That's a citizen. That you've got wealthy Asian people coming here, setting up in birthing centers so their kids can get citizenship. That's just crazy. All right. And then you've got the illegal immigration component. And what the original, the late, great, Anthony Scalia argued. He had this idea of the microwave oven. All right. And this is how he illustrated it. He said, look, when we enacted a law that said you shouldn't steal things prior to the invention of a microwave, and then a microwave came about, we had to modernize that law to anticipate that, you probably shouldn't, you shouldn't steal a microwave either. Right. Are you with me?
Yeah.
Right. And Justice Alito is who's still on the bench. He's basically harnessing that argument and saying that's how you are really a textualist. That's how you stay to the letter of the Constitution and the law, but you are modernizing things as things happen. So now how do you apply that principle today if you know that Alito and Scalia, the late Scalia there, would both be against birthright citizenship? They're essentially saying, look, the writers, when this portion of the Constitution was enacted, illegal immigration as it stands today did not exist. It was just completely an unknown thing. So you can't take something that was so narrowly focused and just apply it textually for the end of time. Otherwise, you're going to end up with absurd results. Do you like it or dislike it, Chris?
I don't know that I have an opinion. Sticking true to form, we don't all have to have opinions on every hot button issue. But I do, I'm with you. And I do love discussing original intent. I'll discuss that with you every day because some people, and in school, they like to teach us that the Constitution is a living document, which I abhor that statement. But we do have to adjust. We do have to adapt for sure. But we do so by applying the original intent. So when this law was written, what would they have intended it to apply to had they known about modern issues? They didn't know about modern issues. And yes, we agree that it does need to cover all issues. But do we just say, oh, well, this is now the new birthright and therefore it applies? And that's clearly how the law has been applied for as long as we know. And now there's this other argument on the other side saying, well, okay, but you're kind of misapplying a law that had they known about this other issue, they certainly would not have allowed it to apply to that.
It was 1868 where the 14th Amendment was ratified. It was about Reconstruction. And, this is, they're wanting to consider this idea of what modern illegal immigration looks like in the same way to how we have historical exceptions for the children of foreign diplomats or Native Americans. That's how it's being applied. So,
right. I mean, they needed a way to say, okay, all these people who were previously slaves are now free people. We must give them all the rights. They are now citizens. This is our way of doing that. And that is why we had those post-Civil War amendments.
Yeah, absolutely. Okay, so let's go ahead and talk about what we're going to do on our show today. This is one of our shows where we're just going to do one thing. We're going to do it well. You just had a deposition today. I'm just going to interview you on what a deposition looks like, okay? And this isn't going to be about the specific deposition that you did. We're just going to talk about generally what going to deposition is like. All right. So we represented the defendant in this case. Where was the deposition held, Chris?
It was at the plaintiff's counsel's office.
Okay. Now normally you would say, if you're presenting your defendant, often they would you would normally hold that at our office. But in this case, we more of a virtual first firm. So we used their office. Do you think that gave an amazing edge, Chris? Like you're walking into their territory, or does it not even matter?
No, I don't think it matters. And I like using nice offices. So when people have the nice big offices, I like going to their office.
Yeah, it's actually nice. It's like, hey, you guys, you idiots, you pay for the overhead, right? And thank you for the water and the coffee and the chocolate and all that stuff, right? Everyone was nice. I'm not going to mention the name of the firm. Everyone was nice to you, Chris.
Hey, it brought me back, because as you consistently point out to me, sort of the old office model is going away. And so I like, me, I like those offices. We used to have an office that we used to go to, and your office was all the way down at the end of the hall. And I remember those days.
No whiskey card at this office, though, right? I just want to be clear. They didn't bring the whiskey card around. It wasn't 1868.
They didn't. I'm sure the senior partner has whiskey in his office. I would be disappointed if he didn't.
Okay. All right. So you show up, the depositions at their office. The court reporters there, was it a video or a stenographic?
No video. And she was even surprised because she said, wow, I feel like everybody's doing video depos now. And I said, yeah, people do tend to favor the video, but no, just a stenographic recording.
Wow. So you're spending the money on the fancy office, but you're cheaping out on the video, and you're just going to a stenographic recording. I don't
want to make it look like we're casting stones at people on the other side of active litigation, but no, I guess they just didn't feel like it was necessary to have our guy on videotape.
Yeah, well, they're going to get a bunch more depots later, but anyway, that's normally not the case. This was a special kind of proceeding. Normally, you get one shot at this, right? If you're in a regular lawsuit and you get one shot at deposing the other side, you don't get to come back for second bites at the apple, right?
Typically, although people try to find ways around it, like suspending depositions and saying, "Oh, we're going to take this to the judge. Your person's not being cooperative."
They come back and do it again.
Feisty these days.
Yeah. Okay, so everybody sits down. Everybody has their water, and then so tell me what happens next. So the attorney who's doing the deposing, who's asking all the questions, does he start off with the standard spiel? Like let's go on the record. And, Mr. Smith, you realize that you're under oath, the stuff that everybody says.
Yeah, he did that. I mean, he was a seasoned attorney. He was obviously taking 100 depots. So he went through everything and, was very, very meticulous about you're under oath. And if you're found to have lied here today, that will be perjury. And, perjury is a criminal offense. So it was, it's pretty intense. And sitting in the witness chair is not fun. So, starting off like that, being told, hey, if you say something wrong here today, you could be criminally prosecuted for it is not fun for our client.
Should we set the client up? I don't know if we did in this case, but isn't it a good practice to hey, the client, they're going to say all this stuff. Don't let that freak you out.
Yeah, I do. And I say, look, they're going to say, this is just like you're in the courtroom. This is just like, you're testifying in front of a jury. And it is. But we're here. We're in the office. I will object to anything objectionable. He's just going to ask you questions. You're just going to answer his questions.
Yeah. And so he starts out and then he finally gets to the subject of it. Then he says, and then what does he say? He just starts asking questions, right? Like, what did you feel like his structure of questioning had an outline to them, or were they random? Or sometimes you talk about the circular approach, or what do you think?
No, it was definitely very structured, started out with background, started out with, just kind of laying the foundation and then getting into the facts of our case and then the issues that are in dispute. And as the lawyer, why he's asking every question, what element he's targeting when he's asking specific fact questions, but he's doing it in a very conversational way.
Yeah. What did he start out? So a lot of them will start out with just the most, basic of background stuff. Like, how old are you and where are you from and how many children do you have? And are you married? Did he do all that?
He didn't do that. Work experience was about as far. Education. Everybody asks about education. Yeah. He didn't, I don't think he asked if he was on drugs. A lot of attorneys ask if you're on drugs or if you've taken anything or if you've suffered any kind of debilitating accident that's going to affect the truthfulness of your answers today.
Yeah, I hear that one a lot. I had one of them where I was deposed. He asked me if I passed the bar on the first time.
So they wanted to know how smart you were.
I did. I want everyone to know, all of our listeners to know I did. I passed it on the first time. So, okay. So he had a pretty structured approach to the questions. Now, did the client, was he ornery? Did he fight back? Did he answer the questions pretty well?
Least ornery client I've ever had. I won't say anything about that. Yeah, a lot of times I have to warn the client against that. Like, hey, you don't need to fight the guy. Okay. If they ask objectionable stuff, I will object. If you can just answer succinctly. You don't have to give away the farm, but at the end of the day, discovery is about them learning what the facts are. And so when they ask questions, you got to answer them.
Yeah. But you tell them, and I think this is important advice, you're not going to win anything at the depot. They're asking you the questions. You just answer them. You're not trying to prove your case.
No, absolutely. And I always liken it to speaking to the police. So never speak to the police. I don't know if that's a hot take, but never, ever speak to the police. So they're not here to help you. They're not going to talk to you and say, well, sir, thank you so much for your time. You are correct. You are innocent. They are going to look for every little thing. And if you slip up or you misremember something, or if you say something inconsistent with somebody else who misremembered something, they are going to say, well, that's inconsistent. We're going to bring you down to the station. So don't give them any more than you need to. If they ask you what time it is, tell them what time it is.
100% agree. That's a tangent there, but always sad. I'd like to speak to my lawyer, but in this case, you're in the depot and you're there, you're his lawyer, they're asking him questions. It sounds like you've got a good deponent. I mean, so, that's good. And did you make any objections?
I did. wouldn't have earned my money if I didn't make objections.
What kind of, I mean, in Texas, you just say objection form. So
I say objection form the first time, and then every time after that, I just say form.
okay. You shorten out that objection.
Well, let's keep the pace going. He asked this question. I just sneak it in there real quick, get it on the record, let the client answer.
Right. It also keeps, keeps things succinct and moving along. That's good. Did now in Texas, if you say objection form or form, the attorney can stop and say, what, expand on that, right? So tell me what
the nature of the objection.
State the nature of the objection. Did he do that at all?
He did not.
And if he had done that, because the standard is, is the question like, reasonably likely to produce admissible evidence. I think that's the standard or something like that, right? So
yeah, and it's a pretty liberal standard, but I've had people do it to me before. Attorneys that you and I know and love that we've interacted with that said, "Well, state the nature of the objection," and that's when I get real feisty. And you know me, I can get real feisty. I love to say things. Well, counsel, you've asked 6 times. His answer's not going to change. I know you don't like his answer, but you can move on now.
Yeah, that works. I mean, now sometimes if let's say they ask something about, let's say they ask this question, like, Mr. Smith, what did you talk to Mr. Hill, your attorney, about yesterday? That's not necessarily an objection form. I guess maybe it is form. Mr. Smith, don't answer, right?
So yeah, I would just go on the record and I would say that's privilege. Do not talk about anything that's privileged.
Right. That's not one where you just say form to preserve air, because that's what you're doing when you say form. You're preserving, air, right? You'd agree with that?
Preserving my objection so that when it comes in at trial, I can say no, I objected. That's not admissible.
I guess it's not preserving air. Preserving your record that you objected and you didn't waive it and all that kind of stuff. So yeah.
But if it's privileged or if I just, I have been driven to the point where I may not even say objection. I may just say, don't answer that. And they say, are you instructing your client not to answer that, Mr. Hill? And I say, yes, I am.
Yeah. You say it's privileged. I mean, it's not.
Well, even things that aren't privileged, like a year ago, I was in one that I just found the attorney to be insanely abusive to my client. And they try to play the, well, I'll get the judge on the phone. I said, counsel, you go ahead. You are being absolutely abusive to my client. My client is not going to answer any more questions. So unless you're going to change topics, we're leaving.
Sometimes that's a good thing, just walking on it. They don't normally get that contentious. So,
well, you better be right, because if I'm wrong and I tell my client to walk out when they're, under subpoena to show up at a deposition, I'm risking quite a lot of penalties. So I better be right if I tell my client to leave.
Yeah, that's right. That's sort of the nuclear option, right? I mean, you don't want to walk out if there really is a problem. I mean, unless there's a big problem, rather. So, that doesn't happen too often. Okay. How long did the thing take?
On the record, well, we were probably only on the record for 4 hours.
Okay.
It was on the longer side.
He could have taken him. He's a big firm attorney, so he's got to bill the most hours, right? So
I'm not going to comment on. I'm not going to make comments like that. You're the color analyst. I'll leave that to you.
It's really, you're allowed 6. You're allowed 6 under. Was this a level 2 discovery case? You're allowed 6, right?
Right. He gets 6. We broke for lunch, which I was like, oh no, I thought we were going to be done by lunch. And then he said, go to the cafe.
Surely not in they don't have a cafe downstairs or something.
Yeah, cafe downstairs. Yeah.
Sometimes they like to do that. Did you eat with them or no?
No, I walked down there with them. I talked to them, but we can be friendly with opposing counsel. It helps. You're going to be working with them, so it helps.
Sorry, I didn't mean to cut you off, but there's some strategy in that, because he may say, well, it's an opportunity to kind of do a little mini mediation with the attorneys, right?
Yeah. One of my first trials, I did that. I was down in Lake Jackson and, or no, not Lake Jackson, Angleton. His office is in Lake Jackson. So we did do a deposition at his office too. So we were doing the trial in Angleton and we went to lunch, and, like during the trial we talked, and it was just like, we can talk, and we almost settled that case a couple times. Like, we almost settled it in the restroom over a break one time, almost, but we actually went to a jury verdict. We never quite got there.
Yeah. Yeah. Okay. Yeah. So it took about 4 hours. That's a long depo. I mean, if for the kind of cases, like simple cases, it's hard to ask someone 4 hours of questions. I mean, it really is. But
Usually my debos are about 2 hours. So yeah, I expected it to be longer because, again, it's a little bit of a complex case. Big law firms are notorious for, longer motions, longer responses, putting tons of research and appendices onto their stuff. They're just going to put out a lot of work product and kind of bury you that way. That's what you get when you go against big firms. So I knew he was going to go through every invoice, every email. He actually didn't go through most of the texts and emails, but every invoice for sure. It was a lot.
Yeah, I mean, 2 hours sounds about right. I mean, there is what do you think about the strategy if they want to take your client or the deponent longer because you're wearing them down? Do you think there's any evidence of that?
Maybe, I don't know. I mean, what I would tell you that this guy did well was and our person is not. You're asking how ornery he was. Our guy's not an ornery guy anyway. So he didn't have a lot of contentiousness. And so it's not like he really needed to wear him down. It was very conversational the whole time. I don't know. I think if it's contentious, it's just going to get worse as it goes. So I don't know. I could see after a while, the last mediation I had, answers to questions you're not asking. But when you're in mediation, that's part of the beauty of mediation is by 5 o'clock, everybody's really warmed down. Okay, we're ready to settle.
Yeah, that is part of the goal in mediation. I mean, I've done some expert, work where I've been deposed, and I'll tell you, it's for being an expert where you're answering very complex questions. Those longer depots, I do think that can wear an expert down if you're talking about a very complex subject matter, right? So
that makes sense.
Okay, so it ended about 4 hours, and tell me how it ended. You just sort of said, "Okay, I think I'm done. We can go off the record now." Is that sort of how he closed up? No,
that's it. That's it. Usually you take one final break to go over everything with your client, go over your notes, make sure you didn't miss anything. If we got the luxury of doing that at trial, it'd be kind of nice sometimes, because as soon as someone gets off the stand, you immediately remember the key question that you forgot to ask. So it's kind of nice to have that luxury.
I'm a well-hydrated individual. I need to take a break about every hour. Do you think? I mean, I'm serious. Do you think that's unrealistic? Because it's like I really, if I'm sitting there drinking water, like I really do need to go about every hour at my. So do you think that's crazy? Would they just be like, no, you just had a break last night? I know, guys, but I drink the appropriate amount of water. What do you think?
I think that's a personal issue you need to look into. If I'm thinking, well, I can't say no. I would say, of course, sir. I mean, it just lengthens the time we're there, because you talked about 6 hours. That's 6 hours on the record.
Well,
so if you're taking 15-minute breaks, you're adding a whole hour to you being there. I'm the opposite of you. I could sit in the chair for 6 hours. Wouldn't matter.
Well, if I'm doing the expert work, I got to stretch out my bill a little bit, right? So, that's a joke. I'm not really doing it.
I hope not.
That's a joke. Come on. All right. So is there anything let's say you close up. He closes up, fine, you're done. You walk out, maybe a little small talk. You don't let the client talk to the attorney. You maybe talk to your client a little bit and then send your client out the door. Maybe you hang around, talk to the attorney a little bit or not. All that true. You agree with all that?
Yeah. I mean, it depends. A lot of times I like to talk to attorneys after the fact. Now that everything's been out there and, okay, you've got all your questions answered. How do you feel about the case now? But sometimes you want to go talk to your client after the fact too. So you can't do both. You got to pick one or the other.
Yeah. Okay. So you get done, and then what happens? Then the transcripts get ordered. These court reporters, they don't just give you a transcript right there. Tell me how mechanically, how does that work? You wait a couple days, transcripts
Yeah.
get ready.
They type it up. They send it to you. You can read and sign your deposition. So everybody requests read and sign, which means I get to read it and then I sign off on it. If I have any corrections, I can correct it. Now that's not the opportunity for you to change your testimony, because 9 times out of 10, the court reporter did not make a mistake. You said what you said. So if you feel the need to add additional testimony, you can, to say, oh, I misspoke, I meant this, or, something like that. It's probably not a good idea to try to say, no, that's not what I said. But yeah, you are given the ability to read and sign, and then you return it to the court reporter with the signature page, and the court reporter attaches that and submits the final version. This is the official deposition transcript of plaintiff or defendant.
Yeah. What's a stenographic depo running right now as far as cost goes? Could you any idea, or you haven't looked at that?
I don't want to guess. Just their time plus the document itself. $1,000 to $2,000, I would guess.
Okay.
I try not to order copies anymore. Pro tip for anyone listening: you can request a copy of Depositions in Discovery, and so if they have a copy of the deposition, you can request it, and they must produce it, and then you can make your own copy.
That's a great pro tip, because you're saving money there. Yeah, that's a good one. Okay, well, I think that does us for, depos. I appreciate you going through that. That brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you should podcast. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. And tell us you want it publicly answered in the podcast. Everybody have a great rest of your week.